So I'm going to open the conversation today with 14th Amendment. 150 years ago, 14th Amendment was passed. And we are in a juncture that some people are asking how relevant is 14th Amendment to our situation today. So I want to ask you, how far have we come since 14th Amendment went to effect, and what else, how much we have to go? How many areas do we need to invest on and push for progress?
Great. Well, thank you so much for having me here, and for the people in the room and anyone who's watching the live stream or listening to this later. The Constitution of the United States is one of the most powerful legal documents, one of the most durable. It has qualities that make it last, but it also has the ability to change. And the way that the Constitution changes, one is through the formal amendments, but it's also in the way that the people embrace the Constitution, whether we defend it, whether we stand for it, whether we apply its principles fully, or whether we step back from it and let it be taken from us or used against people's rights. So the original Constitution of the United States basically created the separation of powers between the executive branch, Congress, the judiciary, and then the basic structure of federalism with the states. But the Constitution originally had very few protections for individual rights, and those were enacted through the first 10 amendments to the Constitution, which we call the Bill of Rights. So when you think about the constitutional amendments, I think the Second Amendment is obviously very famous. It's always in the news. People can associate the Second Amendment with whether it's collective or an individual right to bear arms. The First Amendment also gets a certain amount of attention, and rightly so. When people ask me what's my favorite amendment of the Constitution, though, my answer is the 14th Amendment of the Constitution. The 14th Amendment does a few things. First, it says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That's a profoundly important sentence. What it says is that there's two paths to citizenship: citizenship by birth and citizenship through the naturalization or immigration process. The reason the 14th Amendment is my favorite amendment is that I'm a citizen because of it. I was born in this country when my parents are both from Iran. I was born in this country in 1973, and that's what made me a citizen. Because of the fact that my parents were Iranians, I associate my citizenship very squarely with this amendment of the Constitution. But every one of us who's a citizen, every last person who's a citizen, it's either by birth or through naturalization. So the 14th Amendment, that's one core plank. After that, it goes on to say that no state can deny the privileges or immunities of a citizen of the United States. And then from there it goes on, and it changes from talking about citizen to person. And it says that no state can deny to any person due process under the law, and that no state can deny to any person the equal protection of the law. So the people who wrote the 14th Amendment did so in the aftermath of abolishing slavery in the United States. The 13th Amendment that immediately precedes the 14th abolished slavery. And at that time, the thought was, well, if you abolish slavery, well then, by definition, the people who are freed from slavery should be treated equally as human beings and as citizens. But immediately, the states that had slavery, as well as the northern states, set about a set of policies to discriminate against free black people. And so the 14th Amendment was necessary to make clear that every person born here is a citizen, that no state can take away the rights of a citizen. But then they switched from talking only about citizens to also talking about persons, when they said that every person is entitled to due process and equal protection. So why would they, in crafting Section 1 of the 14th Amendment, talk about citizens and persons so clearly? Is because they wanted the Constitution to be abundantly clear that it applies on the fundamental rights of due process and equality to every person, citizen and non-citizen alike. So I love the 14th Amendment. I love it because it was the path to my own citizenship, but also because it marks this country's progress in the abolition of slavery and the extension of rights to every citizen and to every person.
Awesome. Thanks. And I think from this we can probably go to the question that is in many people's mind these days. Equal protection for all, basically, persons. I want to basically move to the travel ban that basically affected a specific group of citizens, basically, with certain restrictions and limitations on, movement. Is that something that we can, relate to 14th Amendment? Do visitors from outside the United States, are they considered basically subjects to 14th Amendment?
Yeah, so, being Iranian American and working at the ACLU, the whole run-up in the presidential election with the language of the Muslim ban was quite alarming to me, to other people who are Muslim or from Muslim-majority countries. But I think it was alarming to everyone because our country has a tradition of religious liberty and religious freedom. And the statements of candidate Trump were incredibly toxic in terms of speaking those words about making people of a religion a suspect class or a suspect group. Already, his statements as a candidate had a horrible effect because they gave voice and they legitimized the idea that we can discriminate based on religion. Within days of becoming president, I think it's one of his very first executive actions was the first Muslim ban. So in the design of our system of government, preceding the 14th Amendment in the Bill of Rights is also the Fifth Amendment. The Fifth Amendment is the same due process clause that says that before a person can have their life, liberty, or property taken, there has to be due process of law. Due process means that there has to be a rational basis to the decision of the government. There has to be notice. There has to be a hearing. Usually in the criminal context, it means there has to be evidence, that you have an opportunity to respond to the evidence, etc. Due process is fundamental to the rule of law and, by extension, the equal protection under the law. So the 14th Amendment, we don't usually have to go to the 14th Amendment. We can often go straight to the Fifth Amendment where it deals with the federal government itself. And we also have the nation's immigration laws that are enacted by statute that you can also protect someone's rights. So why was the Muslim ban 1.0 so offensive to our constitutional rights? First of all, it was the embodiment of the statements that Donald Trump had made that he wants to ban the entry of Muslims into the United States. It was the way in which his government officials could give life to that promise. It wasn't every Muslim from every country. They had to cabinet to what his people thought that they could pull off. What was also so offensive about it was that there are people who were literally on airplanes, people who had a visa in their hand, people who were landing on the shores or in the airports of the United States who were being denied entry or who were being turned away. More than that, there were people who were green card holders who were being intimidated into giving up their green cards. None of that had any due process of law. What I love about the court decisions of those days is that it said that even if you're a person who has not yet even set foot on United States soil, that you had gone to a consulate in Dubai or in Turkey and had gotten a visa, and you're in an airplane coming to the United States, you're still protected by the Constitution of the United States. You might not be a citizen. You might not be a legal permanent resident, but even as a visa holder, you're entitled to the due process and equal protection of the law. But what I was the most inspired by at the time of the first Muslim ban was not just that the ACLU lawyers went to court or that the judges made the right decisions. It was the way that the American people responded. In 1941, after the attack on Pearl Harbor and the executive order for Japanese American internment, the ACLU here in the Bay Area, the ACLU of Northern California, we represented Fred Korematsu in a case that went to the US Supreme Court. At that time, the number of people who spoke up on the side of Japanese Americans was extremely few. But when the Muslim ban was announced, the American people responded and rallied around not just the people who were being detained at airports or who were being turned away, but they rallied around the core values of this country, of religious liberty, of welcoming people to our shore as immigrants, and all the traditions that have made us proud to be Americans.
I see. But if we want to go back to the 14th Amendment itself, are there areas that the 14th Amendment is under, are there areas where we can improve? Where are the places where 14th Amendment is not being completely followed or observed that we think we have to invest on?
So the reason this year I'm speaking even more about the 14th Amendment is that this is the 150th anniversary of the ratification of the 14th Amendment. It was adopted in 1868, just a few years after the end of the Civil War. And over the course of this 150 years where we've had the 14th Amendment, it's remarkable to really look at that history. In the 10 years after the abolition of slavery is this period called Reconstruction, in which the United States made incredible progress in advancing the right to vote, education, economic opportunity for and by the newly freed slaves. The way in which the African American community and their allies among many other Americans, including at the time the radical Republicans in Congress, were able to seize that moment and make very fast progress is one of the most inspiring periods in American history. I would argue that the period from the abolition of slavery, that first decade, more was done to advance liberty than even the first American Revolution. To go from the condition of slavery to the gains of the Reconstruction is the farthest distance in the advancement of liberty in American history, full stop. The period of the American Revolution, initially with the Constitution, is remarkably important. But the American Revolution and the original Constitution also strengthened the institution and the law on the side of slavery. It was written into the Constitution. It took the Civil War and the Reconstruction movement to break down the way in which slavery was written into our Constitution and make those advances. That period of 10 years of Reconstruction's progress came to a very rapid halt and was replaced by a very long period of Jim Crow, is the term for legalized segregation. That segregation included the force and power of state laws, of federal laws. It also included horribly unjust decisions of the Supreme Court of the United States in a series of decisions that took back many of the gains of the 14th Amendment. It was also backed by violence through widespread violence, fear, and intimidation against Black people, as well as whites who were involved in voter registration or on the side of equality as well, although the magnitude of the attack was most pronounced against African Americans. That period of Jim Crow or legalized segregation lasted for a very long time until the Civil Rights Movement. So I think we have to look at the long arc of the United States. The American Revolution, the original Constitution, the Bill of Rights, they are profoundly important advances for human liberty and equality. The struggle to abolish slavery, the period of Reconstruction, the movement to secure the right to vote for women. It's one of the longest movements if you look at the duration of time that it took from the time that we secured the 15th Amendment, which protects the right to vote regardless of race. The 15th Amendment was one of the 3 post-slavery amendments. That was adopted in 1870. It took another 50 years until 1920, when the 19th Amendment protected the right to vote regardless of sex. So I think we have to take a bit of a long view of American history. We are in a period where a lot of fundamental rights are under attack. We've been through that before, and the only way we've gotten through it is by every person standing up on the side of equality and freedom and justice and using their voice for those enduring values.
Thank you so much. Now going back to the discussion that we started on travel ban, and later on, I guess, family separation falls into the same category. We saw extreme support from people who thought that this is unjust, this shouldn't be happening. People went to airport, very heartwarming. Although family separation issue is ongoing, we just recently heard that another 1,500 cases of kids that were put under care their cases are missing, they cannot be tracked, and so on. So that issue is ongoing. But the point that I want to get to is that there was this political atmosphere that allowed these two rather cruel acts to go into effect. If a few years ago, probably 5-10 years ago, it would have been unimaginable, things like this happening, like singling out Muslims or separating children from their families in a way that happened and so on. What happened in our political atmosphere that allowed for things like this to actually happen in the first place? What was the root cause, and how can we prevent that? How can we address the root causes of this situation, of anything like this being even accepted by the society?
I think that there's maybe, I'm going to simplify this a little bit, but maybe 2 categories of people. There's a category of people who, after Trump won, woke up and were kind of shocked that this could happen. How is it even possible that a person who says the things they do could win the election? And then there's a second category of people who've been actually dealing with and facing pretty deep-seated discrimination in the United States that has had very deep roots, and for whom this was actually the manifestation of that exact existing set of problems. I think whichever way one looks at it, the current situation in terms of the policies of this administration are at a different level in terms of their cruelty, in terms of how patently they are designed to carry out a policy of exclusion. Going back to the 14th Amendment, of which I'm very fond, the 14th Amendment, it is a chain of words that says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This sentence represents a path from person to citizen. And I think that we have to be very clear-eyed that the totality of the policies of the current administration is to stop every possible point in that path. So it includes the mass deportation of undocumented immigrants without due process. It includes reducing dramatically the number of refugees that the United States will permit to come to the country. A new policy that we have seen through leaked news reports is this idea of public charge. Historically, the United States would deny a path to citizenship for a person who was institutionalized in the care of the government. The idea was that you have to be somewhat self-sufficient to be able to get through the immigration process. They now want to change that definition to include just about anybody who has received any form of services from the government. So that's another attempt to limit that path to legal immigration. So I think that that's a major cumulative set of policies that's designed to keep the United States demographically from changing, and its intended purpose is to keep people out, and very much from Latin America, Central America, Africa, Asia, etc. The idea of like family chain migration, which they are also focusing on, has been the main vehicle through which Asian Americans have immigrated to the United States. There's really nobody who's like immune to these policies of exclusion. At the same time, there's a set of policies that are aimed at the rules of the game and the way in which power itself is distributed. So the attack on the right to vote with the concerted efforts at voter suppression, the political gerrymandering of districts so that it reduces the influence of each voter in their state or federal government, the inclusion of the question about citizenship in the census that has the intended effect both of intimidating people from taking the census, but also of creating the record by which then the government can allocate differentially certain benefits by population according to citizen instead of according to the number of persons. So this is all very serious, and I think that we have to be involved in speaking up for basic principles of equality, fairness, and freedom. So the 14th Amendment, how it itself plays into it is very much at the center of a lot of these debates. The equal protection of the law. Well, who does that apply to? Those words, equal protection of the law, did not make it into the Constitution until the 14th Amendment. Those are the words based on which we've made a lot of the gains for lesbian and gay couples to have equal access to marriage or to other government benefits. So our view is that that principle of equal protection needs to be robust and inclusive, and it needs to be a force to combat discrimination. Other people can view equal protection very narrowly and try to limit its application. And so that's going to be something that gets fought in the Supreme Court in the coming decades.
So at this point, I want to move to some of the topics that are more related to practical aspect of ACLU's work. So we've heard about people power, the grassroots efforts that ACLU is instantiating and around the country. Can you tell us a little bit about people power and what are the ambitions, what are the goals and objectives, where we are and how we can help?
So I spoke before about the 14th Amendment, but I also want people to know I'm a big fan of the First Amendment. And you can think about the First Amendment as something that's a legal protection, but it's actually incredibly beautiful and poetic. And if you haven't taken the time to read the First Amendment recently, I'd really encourage you to. It says that Congress shall pass no law abridging the freedom of religion or to establish religion. That Congress can pass no law limiting the freedom of speech or the right of the people to peaceably assemble or the right and the freedom of the press. And then the First Amendment culminates in that the government cannot limit our right to petition the government for a redress of grievances. So when you read the First Amendment as a whole, it begins from the place of our inner beliefs and our values. Both the idea that the government cannot tell you your religion, nor can the government deny you your religion. And the case on the First Amendment has evolved to be clear that religion includes your conscience in many instances, like your secular beliefs that are deeply held. And then from there, it goes to your freedom of speech and of the press, and your power to assemble as a group and then petition the government for a redress of grievances. So it's a chain from your beliefs to your relationship to government. And this is a very simple point that I'm making. There's a beautiful book written called Madison's Music that's about looking at the First Amendment as a holistic principle. So to your question about people power, our view at the ACLU is that the kinds of assaults that we're facing on our rights are not ones that we can secure only through the courts. They require the participation of people in the exercise of their freedom of speech, in their assembling together peacefully, and in petitioning the government. That is the First Amendment itself. So peoplepower.org is a new flank of the ACLU that's an online platform that allows people to organize in defense of their liberties, in defense of equality, in association with the ACLU. And for us as a longtime legal organization, this was a recognition that while we're going to continue to go to court, the ultimate defense of liberty is people's involvement, exercising their First Amendment rights through organized campaigns like we offer on peoplepower.org.
Very well, thank you. So you mentioned First Amendment, and I want to ask a question that is a little bit related to First Amendment. So this is a discussion that these days being discussed on media to some extent. Some people are worried about giving platforms, unintentionally giving platform to hateful speech. But this is not the first time that hateful speech is appearing. The incident of William Shockley and Yale University from 70s, that's a very famous one. What happened afterwards, there was this postmortem, this discussion of, what are the boundaries, what are the sort of speech that we have to allow to take place. And we know that ACLU has been on forefront of, defending First Amendment. What are your advices? What are your thoughts or, mindset on how we should set the boundary? Where should basically we draw the line between basically a speech that is not going to be tolerated and something that has to be tolerated no matter what? Where is the boundary? What is the guideline?
So this is a great question, and one that is the subject of a great deal of legal thought, social science thought, and people's own conversations about what is that line. I think the basic principle of the ACLU is that we do not want to give that power to the government to decide who can say what and when they can say it. One of the earliest and one of the famous cases that the ACLU brought here in Northern California was a case in a poem called Howl by Allen Ginsberg. So if anyone goes to North Beach neighborhood in San Francisco, you'll come across City Lights bookstore. And they were the publisher, with Lawrence Ferlinghetti, the publisher, Allen Ginsberg, the poet, of this beautiful poem called Howl. The poem talks about gay sex. It talks about drug use. It talks about depression. And those things were considered offensive and obscene. And for that reason, that poem was censored, I believe, by the Postal Service that wouldn't distribute it. So we went to court, this is the 1950s, and won a ruling on the side that this poem can and should be published, and the government cannot censor something because someone considers it obscene. I think as time has passed, a lot of people have kind of lost track of that. And there's a sense that if there's language that's hateful, if there's language that's discriminatory, that we should give the government the power in one form or another to limit the expression of that view. And the ACLU, we still stand by the principle that that would be a really dangerous path to go down. It is dangerous for a number of reasons. One is that we don't believe that force or government power should be used to suppress the ability of a human being to express a point of view. Beyond that, once you create that basis in legal precedent or in other places, that will be used in all manner to restrict all forms of expression that someone finds offensive or discriminatory or the like. Now, what are the limits to that? One is the limit of a threat of violence. If there's a statement that is made that's targeted an individual and it's a threat of violence, that's different. Another would be like sexual harassment or racial harassment in the workplace or in a school, where a person should have the right to free employment and education, free from discrimination. So there are places where there's a limit to it. Google being a technology company, one of the big challenges is on platforms like YouTube or social media platforms, which is an inordinately complex area. But we're mindful of how do you make sure that you don't hand that power to large corporations to then be the deciders of what can be said and what can't be said. But some of this language does cross a line into threats. And so how do you manage that? That's a problem that the ACLU is concerned about, and one that I know companies are also dealing with.
So what are the dangers of overreaction here? So that's something that we see on the progressive side, people like being really worried. Are you yourself worried? Are you like, is there any sort of advice that you can make to people to maybe studying about past, because this is not the first time, this is not the first episode of things like this happening.
My advice would be, let's say there's a speaker who has been invited to come to a university, and there's a group of people who object strongly to the points of view that that person has expressed before. It is equally a freedom of speech of those protesters to protest that speaker's coming. At the same time, you can also just ignore the person and not give them the platform of the conflict that they're also looking for. But I would just say that I don't think it's wise to try to shut down the speaker and to use the protest for the purpose of shutting down the speaker. I think that that goes really into an area that's not like within the realm of a free society. And as satisfying as that might be, the way that that plays out over time, it does not lead to a good destination. Someone might say, well, giving these people the platform to speak will also not lead to a good destination. But I think we have to be wise in how do we make the choices about how we protest, how we exercise our freedom of speech to lead us down a path towards actual freedom and actual equality. So when a person is coming to speak, and if you object to what they have to say, you can exercise your freedom of speech vigorously. And you can protest it, and that too is the freedom of speech. But I would just say where it crosses a line is where we expect government authorities to be the ones to like censor someone, or where we use like our protests in order to shut other people down. I think that's a line that's not worth crossing.
Very well, thank you.
Or even appropriate to cross.
ACLU of Northern California, I want to talk about some California-specific issues. In particular, criminal justice reform is one of the areas of interest that you have been yourself very active in. Can you tell us a little bit about like the activities that Northern California ACLU is taking on that regard?
Sure. Yeah. So, when you get into reading the Constitution, and especially the Bill of Rights, the original 10 amendments, a lot of it is about the operation of the criminal justice system. The Fourth Amendment is the right to be secure in our persons from unreasonable search and seizure. The Fifth Amendment is a due process provision. The Eighth Amendment protects us from cruel and unusual punishment. So for an organization whose mission is to provide for and protect constitutional rights for everyone, the criminal justice system becomes, by definition, a central part of the work that the ACLU does today and has done for the better part of our century of being in existence. Beginning in the 1980s especially, the set of policies in the war on drugs and other policies really led to this rapid growth in our criminal justice system, what we call mass incarceration. And that period also marks a very rapid increase in the number of people of color, especially African Americans as well as Latinos, being part of that system of incarceration. In the arc of what we were talking about with the 14th Amendment, there's a wonderful book written by Michelle Alexander called The New Jim Crow that a lot of people have read. It's gotten a lot of attention. And Michelle makes the argument that the system of mass incarceration became the next manifestation of the previous system of racial segregation that was created after the period of Reconstruction. And this became the new legalized way in which to promote inequality after the gains of the civil rights movement. So all of that's to say that this is an incredibly important area of work. Over the last 8 or so years, the California legislature, California voters, Governor Brown have enacted a set of reforms to reduce the number of people incarcerated. Initially, part of the pressure was the recession. There was pressure to cut government, state and local government spending, and incarceration is a pretty unwise use of resources, especially the way we've been doing it. But it was also prompted partly by a Supreme Court decision in a case called Plata that dealt with the condition of incarceration in our state prisons. So right now, today, there are a couple of places where we really urge people to be attentive and involved. The first is our county prosecutors, which in California are called district attorneys. They are the most important actor in the criminal justice system. When you think about this problem, 90% plus or minus of incarcerated people are held either in local government or state government. This problem of mass incarceration, there are federal issues that are involved, but it's very much a county and a state issue. So every person should know, like, who is your elected district attorney? If you live in Santa Clara County, San Mateo County, or if you're watching this anywhere else, there is someone in your county government who is your representative, the advocate of the people in the criminal justice system. And at the ACLU, we're asking people to know who that official is, call that office, and ask them to pursue policies that reduce incarceration, that promote alternatives to incarceration. So that's one major area. And I mean, for the people in the room, raise your hand if you know who your district attorney is for your county. So for the people watching on the webcast, there's a lot of shrugging and very interesting facial expressions that all say, we don't know. So I would make that your assignment today. Look up who is your county district attorney and make a phone call to that office and say, I am concerned about the fact that I live in a country that is the world's leader in incarceration. And I'd like to know what are the steps your office is taking to dramatically reduce the number of people who are locked behind bars, to find alternatives to incarceration for people with mental health problems or for people who can be set on a different path. And then centrally, what steps are you taking to address racial inequality in the decision of who to charge and what charges to pursue? I think for any of us, whether we're a citizen or a person who's not a citizen, to abrogate our voice in our criminal justice system and to not hold these people who are elected accountable is giving up part of our responsibility, because they are carrying out these policies in our name as the elected representative of the people in court. So that's part of our responsibility to check that and to rein it in. A second big area is bail. And I think that that's a space in which we are very active. More than half of the people who are held in our county jails are people who are not yet found guilty of a crime. They've been charged of a crime, and they're being held awaiting trial. In the United States, when you are charged with a crime, you have an opportunity usually to post bail. And the Constitution actually says that there shall not be excessive bail. But when we live in a time and an era where there's so much economic inequality, most Americans cannot handle like a $400 car emergency, let alone have to pay tens of thousands of dollars in bail to await trial outside of jail. So what you do is you post a bond through a commercial bail bond company. The commercial bail bond industry, the way it works is that if your bail is, say, $50,000, the $10,000 of it is non-refundable. So even if you show up to court, you don't get that back. And so for a lot of people, that then creates this cycle of debt and contributes to poverty. And so even if you are innocent, even if you meet every court date, you're still left with that economic penalty. So replacing bail requires us to be very thoughtful about what do we replace the system of commercial bail with. I don't think there's much to be said in defense of commercial money bail. It's kind of hard to justify the idea that a person who has money can secure their freedom through bail, and a person who doesn't languishes in jail awaiting trial. It's pretty hard to defend that system. I think we've done a good job of making the case for why we need to make the switch. But I think that the alternative is one that needs to be very carefully thought through to be one that reduces incarceration while people await trial. And we could talk about that some more if you'd like.
Didn't the city of San Francisco just pass something that eliminates the requirement of bail or the?
Yeah, so it's a great question about whether San Francisco voted to end bail. There's a movement around the country to end commercial bail and switch to a system where a person can receive services, be out of jail while they're awaiting trial, with rare exceptions if the person poses like an imminent threat to public safety. A lot of local jurisdictions are adopting reforms to bail. There's another related issue, which is around fines and fees that are charged to criminal defendants or people who've been in jail. And jurisdictions like San Francisco and Alameda County are moving in the direction of eliminating those. But California has not eliminated, well, the legislature just passed a bill, SB 10, that the ACLU originally sponsored and supported, but we ultimately withdrew our support and opposed it. What SB 10 does is it ends commercial cash bail, but what it created as an alternative creates too much detention. There's big categories of people who will be presumed to be held in jail that we just felt that that is not the direction that the bail reform needs to go.
Data shows that school segregation is getting worse. What do you consider as a successful long-term plan to improve the integration?
Oh, great question. That question is from Anonymous. Good job, Anonymous. You know, the relationship of school segregation really also goes with housing and residential segregation. So when it comes to like actual segregation in terms of schools, after the Brown versus Board of Education decision in 1954, which is as important as the Supreme Court as we have had, what that said is that we will not tolerate separate and equal schools. And there was a set of policies that went into place to create integration and provide more access to equal educational opportunities. Subsequent Supreme Court decisions said that that responsibility does not cross school districts. It's only within a given school district. So to the extent that our neighborhoods and our cities are so segregated that people cannot afford to live anywhere in Santa Clara County or Alameda County because of the cost of housing or in the vicinity of a school district, it's very difficult under current Supreme Court precedent to create more diverse schools across those school district lines. Within a school district, school districts can actually adopt a number of policies to make sure that the schools are diverse. And actually, the ACLU has had a number of cases here in California that try to do that within the bounds of state law. There's a Proposition 209, which eliminated affirmative action based on race or gender, that also has this negative effect on the ability to create diversity in schools, but there's ways to do it still within the law. On education, though, there's a whole set of other issues that deal with access to adequate funding for low-income kids and kids of color. Also, one of the big issues we deal with is the significant racial inequality in school suspensions and expulsions, where the research shows that for very similar behavior, especially the most extreme is black boys, face very harsh punishment compared to other kids in the schools. So those are a set of issues around education in which we're very active.
Yeah, the preamble to the First Amendment said Congress shall pass no law, ...
Yeah.
And it seems that there's a great deal of misunderstanding in the populace about that part of it. Can you comment on the legal ramifications of, say, the social media ban of Alex Jones?
Yeah, so the First Amendment, as you said, does say Congress shall pass no law. And then it goes on to fill that out. So that has been understood to mean that a mayor, a president, a sheriff, a school principal, that they cannot unconstitutionally violate your freedom of speech as well. So the Congress shall pass no law is inclusive of other actors in government. And actually, it's the 14th Amendment, and part of why it's so powerful is that it's the 14th Amendment that took the rest of the Bill of Rights and applied it to local and state government. Until that time, something like the First Amendment didn't yet apply to schools or to cities. So the 14th Amendment sweeps in the rest of the Constitution and applies it to local government. But the First Amendment itself does not directly regulate private conduct. The First Amendment doesn't limit my ability to speak to you, and it has limited applications when it comes to private companies or private platforms. Even its reach in private universities is limited. So there is some ways in which the First Amendment is limited, but I think the principle of freedom of expression is one that we embrace and want to apply in as many settings as possible.
So next question on the door is that what are learnings and guidance we can take from the period of Reconstruction to launch a movement for equality and renewed commitment to constitutional rights for all? How do we not repeat elements of history?
So thank you for the question about Reconstruction. I think for anyone, if you didn't hear, the question is, what are the lessons we can take from the period of Reconstruction that we can apply today? And also, how can we make sure that we don't make the same mistakes in the past? There's some really incredible books written on this subject. In the last 3 years, I've read more books than I think I did cumulatively in all of college. Because I've been really trying to learn about this period of American history, which is full of important lessons. I would say the first and foremost, the bedrock lesson is the importance of protecting the right to vote, but also exercising the right to vote and running for office. The period of Reconstruction, in just a few short years, there were thousands of African Americans who ran for and were elected to office throughout the country. And I'm actually quite heartened to see how much energy there is right now in both protecting voting rights, but also encouraging people to vote and people showing more energy in that area. But the great warning of the period of the end of Reconstruction is the way in which the courts can really abandon their responsibility when it comes to equality and freedom. And that's where it's so incumbent on all of us to, not all of us can be a judge. And so we have other branches of government in which we can exercise our power. And for the people who are involved in the judicial system, it is so important for them to uphold the rule of law and the principles of equality. There's a set of Supreme Court decisions that very quickly came one after the other. The most famous is Plessy versus Ferguson, which allowed for explicit racial discrimination to stand, even though we had just abolished slavery and passed these incredible constitutional amendments and statutes. So I would just say we have to just be super alert, super active, and do everything we can in every facet of our lives. And on that point, what I would just say is, we have certain rights and responsibilities as persons, whether we're citizens or not. We should use those. We have certain rights and responsibilities as citizens uniquely. For example, the right to vote, we should use those. We also have rights and responsibilities in our companies and in our associations. And so for people who work in Google, your company has incredible reach, incredible power. And as you're looking at the future of artificial intelligence or the applications of your technology, there are enormous consequences for freedom, for liberty, for equality, that you as the stewards of this technology are actually in the best position to see and address at the source. Ultimately, policymakers and the public have to weigh in too, but I think you all have a certain set of responsibilities that I would really encourage you to, and in many ways you already do, exercise with a great deal of responsibility. And I would really encourage you to embrace that role as being that guardian right at the source of the code itself, or as the application or the idea is being developed.
Thank you. Audience question?
So I was wondering, are there any active efforts going on in ACLU to fight the travel ban? If yes, what? And if not, why?
Okay. So the Supreme Court upheld the travel ban 3.0. And the Supreme Court's say is the final say when it comes to the judicial system. The way in which we will continue to fight the travel ban ultimately will be through legislation in Congress. Congress can change that. A future president or a future administration can revoke it, can change it. Ultimately, there will also be other cases that will go up to the courts. So on July 5th, the ACLU of Northern California filed a case on behalf of an Iranian-American family related to how they were being treated under like the waiver provisions or under other provisions that should be in place. So the short answer to your question is we will not rest and we will not give up until this policy of the executive branch of the United States government is changed and replaced with a system of immigration that's not based on nationality or is not based on religion or other aspects of protected human characteristics.
But there are no active sort of direct efforts for it, right?
There are some of the groups we work with have brought like a class action case on the waiver provision, but there's not a new path on litigation after the Supreme Court ruled on the issues that the court already ruled on. But I think that's where the family separation issue is so important. That policy of separating children from their parents has many of the same qualities as the travel ban. It is incredibly cruel, inhumane, and unjust. It is motivated by the same basic prejudice and principle of trying to deny that opportunity for people to come to the United States. And it also has all of the same characteristics of being completely irresponsibly conceived and executed, such that they can't even find these children. So we may need to move our fight from one arena to another arena, but it's all still protecting that same principle of due process and equal protection under the law. And that's where I will say, as an Iranian American, and as a person who has earned his citizenship because of something like the 14th Amendment, and to the question of what are the lessons, that's where we all have to pool our resources and pool our commitment, not just to protecting our individual situation, but protecting that basic principle of equal protection under the law, due process, and the rule of law. If those ideas are strong, they can be strong for all of us. But if those ideas become weak, or if we abandon them for one group, it is the beginning of abandoning it for everyone. So the rights of women to birth control, to contraception, to abortion, that is a fundamental issue of equality. The rights of lesbian and gay couples to love the person that they love. The right of a person who is transgender to live their life free of discrimination and to be able to live their life safely. These are issues that we have to all be in the circle of protecting those freedoms and rights, because we're all going to be in it together. I think if there's one lesson from American history, it's that. It's that when we come together in defense of that basic set of commitments and principles, all of us do better, every one of us. When that right starts to be weakened or abandoned, then it starts to take it away from every single one of us. So to your great question, I would say we will persist, and we'll find every possible avenue to address the issue of the Muslim ban. But the way we will all do that is by working together on the whole package.
In addition to the important national issues that you're working on, what are the specific things that Google can help to the ACLU of Northern California? How can Google as a company help? How can we as Googlers help?
I would just encourage every Google employee, whether you work here in Mountain View at the headquarters or anywhere in the United States or anywhere in the world, to please be involved. I would encourage you to have a plan around the following things. One is like your charitable donations. The ACLU appreciates that support and we have many other organizations we work with that also need that support. So I think one is like, what do you do in your charitable giving as a person? I think second is in terms of your involvement in your activism, in voting, in being involved. Whether you're a citizen or not, you have the freedom of speech. The right to vote is the one part that only a citizen can do in the United States. And then I would encourage you as people who work in one of the most powerful and influential companies in the world is to develop products and services that can facilitate human communication, human participation, and to be really watchful of those ways in which your technologies can create a backdoor towards abusing people's rights. And I think that's a place where Google employees have a disproportionate role or influence in terms of making sure that your technology facilitates human liberty and equality as compared to being a tool that can be used for those opposite purposes.
Thank you so much. Thank you for attending.
Thank you very much.